ಸ್ಕ್ರೀನ್ ಶೇರ್ ಆಗಿದೆ ಈಗ.
Not yet, sir.
Just a minute. ಈಗ
ಇಲ್ಲ ಸರ್, ಬರೀ ನಿಮ್ಮ ಹೆಸರೇ ಕಾಣಿಸ್ತಾ ಇದೆ.
ರೆಕಾರ್ಡಿಂಗ್ ಸ್ಟಾಪ್
ಭುವನೇಶ್ವರ ಸ್ಕ್ರೀನ್ ಶೇರಿಂಗ್ ಅಂತ ಕೊಟ್ಟಾದ್ಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಆಪ್ಷನ್ ಇದೆ ಅದು.
ಸರ್, ಸ್ಕ್ರೀನ್ ಶೇರಿಂಗ್ ಅಂತ ಕೊಟ್ಟಾದ್ಮೇಲೆ ನಿಮ್ಮ ಮೊಬೈಲ್ ಇದು ಸ್ಕ್ರೀನ್ ಓಪನ್ ಆಗುತ್ತೆ ಸರ್, ನಿಮ್ದು ಲ್ಯಾಪ್ಟಾಪ್ ಅಥವಾ ಇದರದು. ಅಲ್ಲಿಗೆ ಹೋಗಿ ಫೈಲ್ ಅಂತ ಹೋದ್ರೆ ಯು ಕ್ಯಾನ್ ಕ್ಲಿಕ್ ಆನ್ ದ್ಯಾಟ್.
ಫೈಲ್ಸ್ ಅಲ್ಲಿ ಹೋದ್ರೆ ಡೆಸ್ಕ್ಟಾಪ್ ಹಾಕಿದಾಗುತ್ತೆ ಇಲ್ಲ.
ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಂತ ಇರುತ್ತೆ ನೋಡಿ ಸರ್, ಅಲ್ಲಿ ಮೇಲೆ ಒಂದ್ 3 ಇದು ಬರ್ತಾ ಇದೆ ನೋಡಿ ಐಕನ್.
ಅದು ಬೇಸಿಕ್ ಅಡ್ವಾನ್ಸ್
ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಡ್ವಾನ್ಸ್ಡ್ ಅಂತ ಇದೆ. ಅಲ್ಲಿ
ಫೈಲ್ಸ್ ಅಂತಿದೆ.
ಹಾ ಸರ್,
ಮೈಕ್ರೋಸಾಫ್ಟ್ ಶೇರ್ ಪಾಯಿಂಟ್ ಅದಲ್ಲ
ಅದಲ್ಲ ಸರ್.
ಇದು ಇನ್ನೂ ಆಗಿಲ್ಲ ಅಲ್ವಾ?
ಇಲ್ಲ ಸರ್, ಇನ್ನು ಓಪನ್ ಆಗಿಲ್ಲ.
ಅದು ನಂದು ಇದ್ರಲ್ಲಿ ಯೂಶಲಿ ಹಿಂಗ್ ಲಾಸ್ಟ್ ಇದ್ರ ಮೇಲೆ ಆಗ್ತಿತ್ತು ನನಗೆ.
ಓಕೆ. ಅಡ್ವಾನ್ಸ್ ವಿಡಿಯೋ ಫೈಲ್ ಅಲ್ಲ ಸರ್.
ಅಲ್ಲಿ ಅಡ್ವಾನ್ಸ್ಡ್ ಇದೆ, ಫೈಲ್ಸ್ ಇದೆ, ಬೇಸಿಕ್ ಇದೆ. ಡ್ರಾಪ್ ಬಾಕ್ಸ್ ಹೋಗ್ಬೇಕಾ?
ನೋಡೋಣ ಹೋಗಿ ಸರ್, ನಾವು ನೋಡಿಲ್ಲ ಇದನ್ನ. ಡ್ರಾಪ್ ಬಾಕ್ಸ್
ನೋಡ್ತೀನಿ, ಡ್ರಾಪ್ ಬಾಕ್ಸ್ ಹೋಗ್ತೀನಿ.
ಡ್ರಾಪ್ ಬಾಕ್ಸ್ ಅಲ್ಲಿ ಶೇರ್ ಸೌಂಡ್ ಆಪ್ಟಿಮೈಸ್ ಫಾರ್ ವಿಡಿಯೋ ಕ್ಲಿಪ್ ಅಂತ ಇದೆ ಸರ್, ಅಷ್ಟೇ.
ಸರ್, ನಿಮ್ ಸೆಷನ್ ಭುವನೇಶ್ವರಿ ಮೇಡಮ್ಗೆ ಶೇರ್ ಮಾಡಿದ್ರೆ ಅವರು ಸ್ಕ್ರೀನ್ ಶೇರ್ ಮಾಡ್ಬೋದು
ಅವ್ರಿಗೆ.
ಹಾ, ಅವರು ಶೇರ್ ಮಾಡ್ತಾರೆ ಸರ್ ಅದನ್ನ.
ಎಸ್ ಶ್ಯೂರ್ ಶ್ಯೂರ್, ನಾನು ಅದೇ ಮಾಡ್ತೀನಿ ನೋಡಿ.
ಹಾ,
ಐ ಡು ದಟ್ ರೈಟ್ ನೌ. ಒಂದೇ ನಿಮಿಷ ಕಳಿಸ್ತೀನಿ.
ರೀಡ್ ಶೇರ್ ಬರ್ತದೆ.
ಕಳಿಸ್ತೀನಿ.
ಆಫ್ ಐತೆ ಈಗ, ನನಗೆ ಬರುತ್ತೆ ಅದು ಹೇಳು. ಇಲ್ಲೂ ಆಫ್ ಐತೆ, ಡೋಂಟ್ ವರಿ. ನಂದು ಇಲ್ಲಿ ಮಾತಾಡು.
ಭುವನೇಶ್ವರಿ ಮೇಡಮ್ ಮ್ಯೂಟ್.
ಜಸ್ಟ್ ಕಳಿಸ್ತಾ ಇದ್ದೀನಿ.
ಓಕೆ ಸರ್.
ನಾನು ಈಗ ಬಂದೆ ಹೊರಗಡೆಯಿಂದ, ಅದಕ್ಕೆ.
ಓಕೆ ಸರ್, ಇಟ್ಸ್ ಓಕೆ, ಟೇಕ್ ಯುವರ್ ಟೈಮ್ ಸರ್.
ಭುವನೇಶ್ವರಿ, ನಿಮ್ ಮೇಲ್ ಐಡಿ ಹೇಳಿ.
ಸರ್, BHUVANA.
ಒಂದು ನಿಮಿಷ.
ಸರ್, ನೀವು ಮಾಡ್ಬೋದು ಅನ್ಸುತ್ತೆ. ಈಗ ಕ್ಲಿಕ್ ಮಾಡ್ತಿರಲ್ವಾ ಸರ್, ಒಂದು ವಿಂಡೋ ಕಾಣಿಸುತ್ತಲ್ವಾ ನಿಮಗೆ ಶೇರ್ ಸ್ಕ್ರೀನ್ ಅಂದಾಗ, ಆ ವಿಂಡೋ ಮೇಲೆ ಕ್ಲಿಕ್ ಮಾಡಿ ಸರ್, ಶೇರ್ ಅಂತ ಬಂದ್ಬಿಡುತ್ತೆ. ಸ್ಕ್ರೀನ್ ಅಂತಿದೆ ಅಲ್ವಾ, ಆ ಸ್ಕ್ರೀನ್ ಮೇಲೆ ಟಚ್ ಮಾಡಿ ಅಲ್ಲಿ ಶೇರ್.
ಈಗ ನಾನು ಏನ್ ಮಾಡಿದೆ, ಶೇರ್ ಸ್ಕ್ರೀನ್ ಮಾಡಿದೆ.
ಈಗ ಶೇರ್ ಅಂದ್ಬಿಟ್ಟು
ಈಗ ಏನ್ ಮಾಡ್ಲಿ?
ಈಗ ಶೇರ್ ಸ್ಕ್ರೀನ್ ಮೇಲೆ ಕ್ಲಿಕ್ ಮಾಡಿದ್ರಲ್ವಾ, ಈಗ ಒಂದು ವಿಂಡೋ ಓಪನ್ ಆಯ್ತಾ ನಿಮ್ಗೆ? ಬ್ಲೂ ಕಲರ್ ಆಗಿದೆನಾ ನಿಮ್ಗೆ? ಎಂಟೈರ್ ಸ್ಕ್ರೀನ್ ಅಂತ ಕಾಣಿಸ್ತಾ ಇದೆ ಅಲ್ವಾ?
ಬ್ಲ್ಯಾಕ್ ಕಲರ್ ಅಲ್ಲ?
ಮೂರು ಆಪ್ಷನ್ ಇದೆ ನೋಡಿ ಸರ್ ಮೇಲೆ, ಸ್ಕ್ರೀನ್ಸು, ಡಾಕ್ಯುಮೆಂಟ್ಸು, ಅಡ್ವಾನ್ಸ್ ಅಂತಿದೆನಾ?
ಇದೆಯಲ್ಲ, ಅಡ್ವಾನ್ಸ್ಡ್, ಬೇಸಿಕ್, ಫೈಲ್ಸ್ ಅಂತಿದೆ.
ಬೇಸಿಕ್ ಹೋಗಿ ಸರ್.
ಓಕೆ, ಅಲ್ಲಿ ಹೋದೆ.
ಅಲ್ಲಿ ಒಂದು ವಿಂಡೋ ಕಾಣಿಸ್ತಾ ಇದೆನಾ? ಅದರ ಮೇಲೆ ಕ್ಲಿಕ್ ಮಾಡಿ.
ರೈಟ್.
ಇಲ್ಲಿ ಕೆಳಗಡೆ ಶೇರ್ ಅಂತ ಬಂತು ನೋಡಿ ಸರ್.
ಈಗ ನೋಡಿ
ಶೇರ್
ಸರ್, ಕ್ಯಾಮ್ರಾ ಆನ್ ಆಗಿದೆಯಾ ನೋಡ್ಕೊಳ್ಳಿ ಸರ್. ಕ್ಯಾಮ್ರಾ ಆನ್ ಆಗಿದೆಯಾ ನೋಡಿ.
ಎಸ್. ಈಗ ಸೇರ್ ಕಾಣ್ತಾ ಇಲ್ವಾ?
ಎಸ್ ಸರ್. ಎಸ್ ಸರ್.
ಎಸ್, ನಾನು ಈಗ ಕ್ಯಾಮ್ರಾ ಆನ್ ಇದೆ ಅಲ್ವಾ?
ಸ್ಕ್ರೀನ್ ಇಲ್ಲ ಸರ್. ಸರ್, ನಾವು
PPT ಶೇರ್ ಆಯ್ತು ಸರ್.
ಶೇರ್ ಆಯ್ತು.
Okay.
Your permission, can I start the session, sir?
Am I audible and visible both?
Yes,
Yes,
sir.
sir. Yes, sir. Both, sir.
Okay.
Thank you.
Okay.
Can we start, sir?
Yes.
Good evening, esteemed chief guest, respected principals and distinguished faculty members from various institutions. It's my great pleasure to extend a warm welcome to day 4 of our 7-day faculty development program on criminal laws. We are truly privileged to have with us today our esteemed speaker, Dr. M.K. Matholi, Associate Professor at the Department of Collegiate Education, Government Law College, Holenarsipura, who will be discussing the significant changes introduced by the Bharatiya Nagarika Suraksha Sanhitha 2023. To officially begin today's proceedings, I would like to invite our principal to deliver the welcome address and set the tone for what promises to be an enlightening session. Principal, sir.
Yeah, thank you, Nirmala. Good evening, friends. Distinguished chief guest of today's program, Dr. M.K. Matholi, sir, and all my colleague friends. Thanks for your support in encouraging us in organizing this faculty development program. And the last 3 days, we had discussion on Bharatiya Nagarika Samhita 2023, and today we are going to have important discussion on the substantial changes introduced by the Bharatiya Nagarika Suraksha Sanhitha 2023 by my friend Dr. M.K. Matholi, sir, who is the faculty of Government Law College, Hassan. Sir obtained his MA in Economics, LLM, and PhD in Law. Sir has awarded with gold medal and cash prize for securing first rank in LLM. And he started his career in the year 1995 as a teacher at Basaveshwar Law College, Bagalkot. Taught various law subjects. His areas of specialization is intellectual property law, corporate laws, law of evidence, international trade laws, and personal laws. Sir has worked as a principal research investigator in a Government of India funded research project titled Problems of the Aged and Need for Social Intervention. He has guided several LLM students and guided Open University students for their partial fulfillment of their degree. Sir has published more than 30 articles in legal periodicals and law journals, especially in the area of IPR and human rights. Sir was associated with many institutions, and he was adjunct faculty at Basaveshwara Institute of Management Studies, Bagalkot. He was the coordinator of Human Resource Development Institute of BVV Sangh, Bagalkot for 5 years, and he was empaneled as a resource person and District Training Institute, Hassan. And he trained master trainers at judicial training programs organized by Karnataka Judicial Academy, and he has delivered more than 80 special lectures for government employees on POCSO in 2017, and delivered several lectures for the benefit of school teachers and then students. And Sir has served as Special Officer Law at the Department of Collegiate Education, Bangalore, and coordinate with the government leaders in conducting various litigations on behalf of the government of Karnataka. And he has trained gazetted officers, particularly gazetted professional officers class 1 and 2 on government litigation, conducting rules and constitutional dimensions of RTA Act at Administrative Training Institute, Mysore. And more than that, he is my best friend, one who always helps us in organizing these type of academic exercises. Sir, I take opportunity and I extend warm welcome to you on behalf of Janata Education Society's Vivekananda College of Law, Bangalore. A cordial welcome to you, sir.
Thank you, sir.
Yes,
Thank
I
you,
also
sir.
take pleasure to welcome the chairman of our governing council, Shri M.R. Lakshmanovar sir, and all other members of Janata Education Society. And I take pleasure to welcome each one of you friends. Over to you, Nirmala.
Sir, sorry to disturb you. Saraswati Madam, Mrs. Matoli Madam has also joined,
Oh,
sir. Registrar Karnataka, High Court, Karnataka. Sir. So you
Madam,
can
it's
welcome.
our pleasure to welcome you on this occasion today to hear the lecture to be delivered by your better off. And I know that you are the person one who behind the success, and I cordially welcome you on behalf of Vivekananda College of Law. Welcome. Right.
Thank you, sir, for the welcome address. It's now my honor to request Dr. M.K. Mathodi, sir, to lead us through this highly anticipated and informative session. Over to you, sir.
Okay, thank you, madam. Esteemed Principal Dr. Kempegoda, sir, and coordinator of this FDP, Nirmala madam, and other esteemed colleagues there in Vivekananda Law College, and all the participating colleagues, and all the esteemed participants. I feel it, my privilege to be before you to speak about this new law. This new laws,
Matoli sir,
because we have
sorry to
yes,
disturb you. Matoli sir,
yes,
will you switch on your video, sir?
yeah, just a minute. That's what.
Video on Madkoli, sir. Thank you, sir. Sorry, sir.
Just a minute. Yeah, sorry for that. I was
Thank you.
anyway. Yeah, thank you. Yes. In fact, I at the outset congratulate the organizers for having organized this unique event, because in the next sem we are going to commence with these new laws, 3 new laws as per the dictum of Bar Council of India. We are supposed to teach these new laws, and also that the students must know what the changes are in these 3 laws. So it is very timely that we have arranged this FDP on 3 new criminal laws, and I must congratulate you for that. And having said about that, now let me take up this task which is assigned to me. The topic which is assigned here is the substantial changes that are brought about by this BNSS into the criminal procedure. Before I take you through those changes, important changes, because I think around, if I can pinpoint certain 84 changes, we can, earmark and discuss, but all of the 84 changes cannot be discussed at a length here. So it is my, convenience that I'll take up certain important changes only. Then we'll look to the other things at the end. Okay. At the outset, why this criminal procedure? Because we have these 2 types of laws, substantive laws and procedural laws. We know that Indian Penal Code is a substantive law, and it defines crimes and it prescribes the punishment for those crimes. But having merely the substantive laws is not enough, because unless the punishments are enforced, unless the criminal process is set into motion, the crimes cannot be deterred, the justice cannot be achieved. So it is very much essential to have a proper criminal procedure on record, and accordingly, we have this criminal procedure. But what has happened of late is the law as such relating to this criminal procedure has been changing And since 1973, though we brought in certain amendments, substantial changes couldn't take place. But by 2023, we have brought in a new code, that is Bharatiya Nagarika Suraksha Sanhitha. And that code, what it gives us, that we'll try to see. Before we venture to study that new code or Sanhitha, what is required for this formulation of code on criminal procedure? Three things must be attended to. One is there has to be fair trial. This fair trial must be based on these principles of natural justice. As law teachers or as law students, we all know what is this principle of natural justice. So this entire criminal procedure must be based on principles of natural justice. Then second thing is speedy justice. The victims and also the accused, they should get the justice at the earliest. That is its other principle. And equity, that is fairness. So this is another thing which is required to be seen into in respect of this criminal procedure. Then why this increased attention to criminal procedure in the past, around 50 to 70 years, 50 to 60 years? That is what we are supposed to see here. One thing why we are receiving increased attention to criminal procedure is this human rights approach to justice. After 1948 UDHR and also after the passing of Human Rights Act in India, and this much publication about human rights and realization of human rights, criminal procedures are time and again challenged before the courts. And accordingly, this procedure it must be in accordance with the protection of human rights. That is one thing. Another thing is this criminal procedure must be victim-centric. And now we are seeing three laws. BNS, Bharatiya Nyaya Sanhitha, BNSS, Bharatiya Nagarika Suraksha Sanhitha. The other one is Bharatiya Sakshya Adhiniyam, BSA. These three enactments, if we look to that BNS, because based upon the substantive law, we have to have the procedural laws, namely the CRPC and evidence. Now BNS, from IPC to BNS, Indian Penal Code. Now it is Bharatiya Nyaya Sanhitha. So instead of penal, we have used the term Nyaya, justice. So now the law is justice-centric or justice-based. To whom? Victims. So we have now moved from punishing the victim, this accused. Our attention must be to give justice to the victim. This is how this victim-centric approach has been taken up now by virtue of this new law. And this facilitation of justice in times of globalization, migration, and this temporary abodes. What is happening now because of this globalization is people are migrating between countries, and with globalization, industrial development has also been taking place, and people are temporarily residing in various countries. When that is the situation, when crimes are committed, we have to look into the process, how that process must also change, and that process must also change. Accordingly, this BNSS accommodates all those requirements. The concept of internal aspect of law or internal morality of law, as we could see in HLA Hart or Fuller, see, people obey law because it's moral to obey them, not because there is punishment. This is an internal aspect of law. But this size of the population who obey the law because of morality is being reduced. And it is making the state to go in for increased or compact procedural laws. This is how this increased attention is given to the procedural laws. Now, let me come to these objects and reasons of the new criminal laws. I'm not taking up the BNSS alone here. What is happening to all the three laws, just to give a caption of them, information technology has been part of every walk of life now. And accordingly, information technology, it is investigation or trial. Information technology has to be part of these processes. Accordingly, to adopt this IT into the legal processes, these new laws have been brought in. Then another thing is this removal of colonial terms. So in these earlier laws, IPC, CRPC or Evidence Act, we had these terms India, Instead of India now, the new laws refer to Bharatiya, and the other laws, which were other terms which were there, were this barrister, vakil, etc. These are now overdone, and these terms are not used now. Only one word advocate is used. Then metropolitan magistrate, all those terms are done with now. So we are now coming to the simpler terms. So Indianized terms, that is another object. Then the consolidation of section. What has been happening in all the three, legislations is the sections are consolidated. Sections pertaining to one single subject matter, which were spread into different areas, they are consolidated into one part or few sections. So there is, in a way, a consolidation of sections. Then another important feature of these new criminal laws is transparency and fairness. So the system is transparent and the provisions are very fair to the people. That is very apparent on the face of the provisions itself. So that is another feature of these new legislations. Then all trials may be held in electronic form. This is very crucial change which is brought about by the BNSS, new criminal procedure. Section 530, it states that all trials may be held in electronic form now. The word used is may, but means there is nothing is preventing the courts from having all the trials in electronic form now. Then victim-centric criminal justice system is the present day rule now. Then enhanced protection to marginalized sections. This is another object. Then all important thing is witness protection scheme. Now under the new criminal law, that is BNSS, it is mandated that the state governments should come out with the scheme, witness protection scheme, expressly to give protection to the witnesses. Then in petty offenses now, mandatory trials are mandated. These summary trials are mandatory now. So accordingly, there is another important change, that is medical examination. Regarding medical examination, a lot of changes are made in a way, time-bound reports are to be submitted, and individual privacy rights are accorded. So in the course of my discussion, I'll be telling you as to how this medical examination has been improved upon. Then timelines, very important thing. Time frames are fixed for different activities under this procedure. Either it is for judgment or for completion of the trial. Earlier also they were there. Now explicitly it is being stated as to what is the time frame for each of the activities under the criminal procedure. Okay. Now, what has happened to BNSS? Earlier it was CRPC. Now you all could witness that this law, which has come into effect from 1st July 2024, it is titled as Bharatiya Nagarika Suraksha Sanhitha 2023. It replaces the Code of Criminal Procedure 1973. So it received the approval of both Lok Sabha and Rajya Sabha, as it can be seen in the slide itself. And it also got the presidential assent, and then it has come into effect from July 1st, 2024. Okay. Now, before I go to key objectives here, there is one point which I want to make clear at this stage. What is that? Applicability of this law. No, it is stated that from 1st July 2024, BNSS is applicable. There are certain points which I want to make clear. As a matter of general principle, we know that substantive laws cannot be made applicable retrospectively. That is against the protection given under the Constitution. Accordingly, BNSS has also come into effect from 1st July 2024. If any offense is committed prior to July 1st, then the testing and the punishment has to be under the IPC only, not under BNS, because the crime has been committed prior to 1st July. Okay, then that is one thing. Then what about the BNSS? Section 531 of this BNSS specifically states that if any investigation has already commenced, any trial has already commenced as on July 1st, no, only BNSS is applicable, not CRPC. It means if the crime has been committed prior to July 1st, reporting is not yet done, means FIR is not yet registered. but the crime is committed to 1st July, prior to 1st July. Suppose on July 2nd, the FIR is registered. If the FIR is registered on July 2nd, the investigation has not yet commenced. When the investigation has not yet commenced, no, for that BNSS is applicable. But what about substantive law? IPC is applicable, but because the crime is committed prior to July 1st. So this is how we have to estimate the applicability of this enactment. Okay. Having said about that applicability now, let us come to these key objectives of BNSS 2023. First of all, the very object of this new enactment is speedy justice. And this speedy justice must be in consonance with the constitutional and democratic aspirations. And all important thing is this new law tries to integrate technology into the legal processes, whether it is this legal process is investigation or it is this trial before the courts. Recognition of electronic communication. See, under Evidence Act now, oral evidence includes adducing of evidence through electronic means. And document includes electronic and digital records. And also there can be adducing of evidence through video conferencing. All these are now legalized, legally recognized. So there is legal recognition of the electronic communication. Then specific timelines are laid down, including for this judgment giving and all. Then citizen-centric approaches are the important objects of this act. Now, certain new definitions. The BNSS, it provides certain new definitions, and few of them which are important for the purpose of the study are, first of all, this audio video electronic means. It means any means or any device by which audio video communication takes place, that is included within the audio video electronic means as per section 2(1)(a). Bail refers to the release of accused. Important term, because earlier it was not defined. Now it is being defined as a release of the accused. Okay, under the conditions laid down by the code. Bail bond and the bond. These two terms are also defined here, and they are self-explanatory. Then electronic communication. This is also defined under section 2(1)(i). That is the communication which takes place through the computer devices or electronic devices like the mobile or even the digital platforms or electronic devices. Then explanation 2(1)j. That is under this section 2(1)j, 1(i), investigation is defined. To this definition of investigation, one explanation is added. That explanation is when any offense which is covered by any special legislation is being investigated, for example, POCSO, NDPS, or Negotiable Instruments Act, when any offense under the special enactment is being tried before the court, the procedure for investigation, whether it is BNSS or it should be the special enactment, is the. Now that point is made clear here, unless it is contradictory to provisions laid down under the BNSS. If the special law procedure is not contradictory with this BNSS, that is applicable here. So these are certain new definitions. Other important insertions are insertions into the new BNSS are this section 35 subsection 7. This is prohibits the arrest without permission of an office. See, in respect of certain offenses or certain persons, for example, a male child below the age of 15 years, a person above the age of 60 years, then all women and persons who are having this physical or mental deformity, then aged persons, all these persons are that the certain privileges or exemptions are given to them under this new section. Then another important thing, section 86, identification, attachment, and forfeiture of the property of the person who is proclaimed person, means whenever a person absconds from the procedure or the legal clutches, there is procedure for now the declaring that person as the proclaimed offender or he's an absconded accused person. That is another change. Then section 105, it also speaks about the recording of search and seizure. Now it is mandatory that whenever the police are taking up the search and seizure, there has to be mandatory recording. This, I think, it is going to reduce the inefficiency of the police and also the misuse of powers by the police. Then attachment, force feature, or restoration of property. So new and very transparent provisions are being brought. Then there is the obligation to conform to lawful directions in preventive action of the police. So there is some public duty. The duty is imposed on the public to cooperate with the police people in respect of preventive detentions. Then another important thing, section 336, very important change is being brought. This change is whenever any evidence is to be adduced by any public official or public servant. For example, in criminal cases, doctors come and depose about the medical report they prepared. And also investigating officers come and depose before the investigation which they have made. The earlier CRPC provided the rule that when the postmortem is prepared by a particular doctor, and even if he is transferred, he has to come from his new place to the old place and he has to adduce the evidence. So also the investigating officer, the earlier investigation officer who was here before his transfer has to come and depose about that investigation. But now the things are changed. The successor in office, whether the earlier officer is transferred or retired, the next person will be able to depose about the evidence, like the medical report and investigation and all. And this is another important change that is being brought about. Then inquiry, trial, and judgment in the absence of proclaimed offender. Whenever a person is absconding, there can be inquiry, trial, and judgment. This is called as trial in absentia, a new concept that is being brought about by this BNSS. Then preparation and notification of WPS. I said witness protection scheme. State governments are now obliged to prepare a witness protection scheme and they have to notify the same. That is a mandatory obligation on them. Then about the mercy petitions also in respect of these death sentence cases, a new procedure has been laid down. Then trial and proceedings to be held in electronic mode now. So this is trial can also be held in electronic mode. Okay, these are the new insertions. Now next thing is certain modifications. What are the modifications brought about by this new criminal procedure? Section 15 first. Superintendent of police can be a special executive magistrate. Now, because earlier what used to happen was, wherever the police need the services of executive magistrate, they had to wait for this deputy commissioner, assistant commissioners, and even the tahsildars for various, for example, postmortems and all. Now that difficulty is done away. Now, even the superintendent of police himself can act as special executive magistrate now. That is one change that is being brought about. Then comprehensive directorate of prosecution. Now, under the new code, directorate of prosecution, even at the district level, is established. In criminal cases, opinion about appeal, sanction regard to prosecute the public servants and all, lot of delay used to take place because the directorate exists at state level. Now, even at the district level, there can be directorate of prosecution now. This is a new change being brought. Now, another thing is arrest. If a person is infirm or above the age of 60 years and he cannot be arrested unless there is permission from an officer not below the rank of deputy superintendent of police. This is how the individual's liberty is respected now. Then when a person is suffering from illness and we cannot compel him to come to the police station to give the evidence or to statement before the police. Now, the police have to visit his residence and take the statement. This is the change which is being brought. Then 37B, a very important provision is inserted. This provision speaks about when in every police station, an officer has to be designated. This officer must have the record about the arrested person the names of arrested persons, the relatives' names, their contact numbers, for what they are arrested, their addresses and all, everything has to even to be displayed by a particular designated officer. So there cannot be any illegal detention at all. This is section 37B. Now section 43, clause 3, handcuffing. A specific provision is laid down under 43 now, wherein accuser may be handcuffed. Who can be handcuffed? The person who has escaped from the custody, or the persons who are habitual or repeated offenders, or if they in heinous offenses like the organized crimes, then if they are possessing illegally the arms and ammunitions, then murder cases, rape cases, sexual offenses, then acid attacks. In all these cases, human trafficking, handcuffing can be there. This is what is stated. But this new provision is likely to be challenged before the High Courts or the Supreme Court very much, because this is much against the Supreme Court's decision in various cases, especially Sunil Batra versus Union of India, wherein handcuffing is held to be against the fundamental rights. And now the legislation has reintroduced this into the statute book. I don't know whether it will survive. I think in all probability, this will be judicially scrutinized. That is for sure. Now, videography of the process of search and seizure. Now, mandatorily, the search and seizure, first of all, the search and seizure has to be taken up carefully by the police. They should take it up only if it is necessary. If it is taken up, they have to compulsorily go for videography of it. That is how even section 27 search and seizure, the mahjars, under Evidence Act, now they have to be under the videography. Then such videography may be done in mobile phones of the police also, but it is mandatory. Now, videography of section 183 statements is not mandatory. It means earlier CRPC 164 statements we had, though the statements before the police have to be videographed, the statements before the magistrates under 164, they need not be videographed. This is what is being stated under the new law. Now, features of an ideal pre-trial process, whether those features are complied with by this new BNSS, that we have to see for some short time here. Fair treatment by the institution of justice. So every institution of justice must treat the concerned people fairly, especially accused and victim. And there has to be sound and independent judgment by the prosecutors. That is the need of the hour. Then process is adversarial, but it is not unfair. So we are following the adversarial system, but it is not unfair system. Then the criminal procedure must ensure acceptability of the decision. When the police decide to arrest, for example, the accused must be in a position to accept that decision of the police to arrest him. Such must be the convincing stand of the police. So treatment with dignity and respect. Then the concerned persons, whether it is accused or the victim, they must be able to understand the process involved in criminal procedure. Then every person who is likely to be taken into task legally should be given an opportunity of being heard. That is principle of natural justice. Then neutral and unbiased decision making, whether it is police or magistrates or every person concerned in criminal procedure must be involved or must be neutral and should be unbiased. So this is how. An all important thing to be kept in mind in criminal procedure is every person who goes to court cannot win. One party must be winning and another party must be failing. And the failing party must be able to accept the decision wholeheartedly, even though it is against him. Such must be the transparency of our procedure. Such must be the convincing elements in our criminal procedure. That is the object of law. But when the institutions like the police and the courts do not perform their functions up to the mark, I think this feeling of the satisfied cannot be there with either the winners or the losers before the court. Then I'll come to very important provision now, which is being changed. Section 173. Information to police regarding cognizable cases. Earlier we had section 154. Usually we call it as first information report. Now, a new section, that is a changed section, number is changed, but almost 80%, the section is same. Only few insertions and additions are made. What are those additions? I'll try to tell you. First of all, section 173(1), what it says, what it suggests. Let us try to understand what it says. Section 173(1). What happens under 173(1) is there is an information to the police, that is SHO, station house officer, regarding a cognizable offense. So information goes to the police. When information goes to the police, what is their next duty? Already we had in place a law laid down by the Supreme Court in Lalita Kumari versus Government of UP. 5-judge bench made registration of FIR mandatory. Means once any information comes to the police, when any information comes to the police regarding the commission of any cognizable offense, he has to register FIR. They couldn't refuse it. That is the law. This is already stated under the in Lalita Kumari case. Okay, that is one thing. First change. Then what is the change made now compared to section 154? What's 173? How 173 is different? Irrespective of the area where the offense was committed. It means when any information regarding any cognizable offense is being given, the police have to accept and register the FIR even if the crime is committed outside their police area jurisdiction. It may not be within their police station jurisdiction. Even then, they have to register it. So it means it is zero FIR. This is the new change being brought about. Then that information may be oral, written, or it is in electronic communication. It may be in the form of message, WhatsApp message, mail, whatever. But when it is, in electronic form, there is slightly some different procedure. Whatever, whether it is oral or written or in electronic form, it has to be reduced into writing by the police. It has to be read over to the informant, and a signature of that informant has to obtain on that copy, and a free copy has to be issued to the informant. This is necessary. In respect of the electronic FIRs, e-FIRs, when the information is given through mobiles or WhatsApp or mail, it has to be registered. It has to be reduced into writing, but the signature of the concerned person has to be obtained within 3 days. Time limit of 3 days is given. Because when the information is given, police have to seek his address and whereabouts and all. They should ask him to come to the station, or they themselves have to go there and they should obtain his signature within 3 days. But if the signature is not obtained, that is not fatal to the very trial itself later. That is not an issue, because when it is coming electronically, they have to register the FIR. So then signature and issuance of copies. Then, but one thing we have to remember, jurisdiction of magistrate and that of the police station as regards trial and investigation continue to be unchanged. Only as regards registering the FIR, you don't need any jurisdiction, police. But to commence investigation and to commence trial, the concerned police or the concerned magistrate have to have geographical jurisdiction. That is not being changed by the new section. That is section 173. Now 173, proviso 1, what it says? When information is given about commission or attempt of sexual offense, it means sexual offense means, it is sexual assault or it is being rape, or, in these cases, when any information is given about the commission of this offense, the recording must be by woman police officer. If the woman police officer is not there, at least woman officer has to record that. That is proviso 1. Proviso 2, victim of sexual offense being disabled. If the victim is disabled, the recording must be at her residence, and there shall be a presence of interpreter or the social worker or even the educator. So this is a mandatory. And plus there has to be videography of this statement. So in sexual offense cases, statement of the woman concerned should be taken only in the presence of woman police officer, and there has to be a videography, and plus there has to be a social worker to assist the woman. That is the change being made. Section 173 clause 2 speaks about copy to informant and or the victim, as the case may be. So free copy has to be supplied. 173 133 says about preliminary inquiry. I'll come to that in my next slide. What is that preliminary inquiry and why it is being specifically mentioned here? 173.4. Refusal to record information. It means if the police refuse to register the FIR, what is the next course of action for the informant or the aggrieved is the question here. The section says under such, it is like the same previous section only, 154. What it says is whenever the police refuse to register FIR, the substance of the information has to be written down and it should be posted to the superintendent of police by the concerned person. The superintendent of police may himself proceed to investigate, or he may cause an investigation to be done by his subordinate. So superintendent of police will do that. It is the old section, also the new section, same law. But the new law adds one point. That point is, if the superintendent of police also do not do anything, if he also do not proceed to investigation, he do not authorize these subordinate to investigate, then the aggrieved can approach the magistrate with an application now. When he so applies, the question is, the detailed procedure is not laid down. When he so applies, will it become a private complaint or a separate procedure is involved? What kind of procedure has to be followed there? This is the new and Samhita is bit silent on that. So this is about the refusal to record the FIR. Now let me come to zero FIR. Under section 170, this section itself we have seen 173. Under 173, we have clearly seen that to record or to register an FIR, the police need not have jurisdiction geographically. Correct. When a police station receives an FIR about the crime which is committed outside its jurisdiction, it is called as FIR. Okay, this is the meaning of this FIR. And it is about cognizable offense. See, any information regarding non-cognizable offense doesn't come under zero FIR. It is about the cognizable offense only. And it is received irrespective of its territorial jurisdiction. Then after registering this FIR, that is outside the jurisdiction, no? After registering this FIR, the police station is required to transfer the relevant documents to the police station which has the jurisdiction over that matter. It means after registering that FIR, along with the necessary documents, the concerned police station which has registered the FIR must transfer that FIR to the jurisdictional police station. That is the rule there. They have to maintain a book, and that other police station, again it has to assign a number to that. Okay, now the police station numbers the FIR and investigates the case. The police station which has the jurisdiction over that FIR, it will number the FIR afresh and it will start investigating that case. One thing we should remember here, zero FIR, though it is specifically mentioned under 173 now, it is not a new concept under the Indian legal system. In the year 2015, the Ministry of Home Affairs issued an advisory wherein it instructed all the police stations in the country to receive the FIRs irrespective of the geographical jurisdiction. In state of Andhra Pradesh versus Panati, Ramula and others, Supreme Court has stated that jurisdiction need not be there to receive the FIR. And also in Satvinder Kaur case, the same thing was asserted by the courts. Then now the BNSS has now given a statutory mandate for zero FIR. Okay, this is about the zero FIR. Now I said, I'll say something about the preliminary inquiry. Under 173, clause 3. Now what is happening now is, if the offense, that is cognizable offense, if this offense is punishable with a punishment which is less than 7 years but more than 3 years. So the punishment is more than 3 years but less than 7 years. That is cognizable offense. Under such circumstances, there is a power with the IO, that is investigating officer. Investigating officer has one peculiar power. That is, if there exists a prima facie case to proceed to investigate, it should proceed to investigate. If not, he may resort for preliminary inquiry. If not, means if he has a doubt whether there is a prima facie case of cognizable offense, if there is a doubt in his mind, then he may resort for preliminary inquiry. But he requires prior permission from DYSP to do that. That is, to do the preliminary inquiry, he needs prior permission from Deputy Superintendent of Police. Because when an information comes to him about cognizable offense which is serious, he cannot be mechanical, saying that there is no, I have a doubt. Even if he has a doubt, he has to go for preliminary inquiry and get himself assured that there is no case or there is a case. A duty is cast upon them. And he has to do it under the nose of Deputy Superintendent of Police because he cannot escape from his basic obligation here. So he has to do that preliminary inquiry with the permission of Deputy Superintendent of Police only, and he should do it within 14 days. The time period to obtain the permission of DYSP is also included within these 14 days. So this is 14 days time period being mentioned. Now, preliminary inquiry under CRPC earlier, was it there? Yes, it was there. Earlier, the previous law was about this preliminary inquiry. Whenever the information received doesn't disclose a cognizable offense, but indicates the necessity for inquiry or preliminary inquiry. It means if the information is not sufficiently disclosing the commission of any cognizable offense, there can be preliminary inquiry. As to what? As to see whether there is happening of any cognizable offense. And to do this preliminary inquiry, they could go verify the records alone. They could not go to field under the earlier law. But now that is changed now. Under the new law now, the prima facie, instead of seeing whether a cognizable offense is disclosed or not, now the investigating officer has to see whether a prima facie case is appearing or not with that information received. If he thinks that there is a prima facie case, he should proceed to investigate. If he has a doubt, then he has to go for preliminary inquiry. And during the preliminary inquiry, if he comes to the conclusion that there is a prima facie case, he proceeds to investigate. Otherwise, he drops the investigation. But everything happens without the knowledge of the deputy, that is DYSP, Deputy Superintendent of Police. So usually, under what cases this preliminary inquiry is being taken up? That is being answered here. Under some cases, number one, in matrimonial matters. When the allegations and counter allegations are there between the spouses, now the IO might have been at doubt whether these things are truth or a reality. Then he may resort for this preliminary inquiry. Then in commercial or economic offenses also, since it involves a lot of verifications of documents, there may be doubts, he can go for it. Then in white collar crimes, he needs to investigate preliminary inquiry. Then in medical negligence, because there may be malafide cases and all, again, there may be necessity for this. Latches, especially when the criminal cases or the informations are lodged after a lot of time gap, even though, limitation period is not applicable. If the information is lodged after some 5 years, 10 years after the murder and all, see, the investigating officers may feel that it is a doubtful case. Under such circumstances, they may go in for the preliminary inquiry. So this is the necessity of preliminary inquiry. And now that is a change being made. Earlier, it was a power of the IO just to see whether any cognizable offenses is being made out in the records or not. Now it is, he has to go to the field and he has to verify whether there is preliminary or prima facie case in that. Okay. Now, after this, let us look to this another one small information, because we are all law teachers here. Evidentiary value of FIR. Section 145 and 157 of Indian Evidence Act. These two sections tell us about the evidence of the evidentiary value of this FIR. When we say that this FIR is not a substantive evidence, and see, the accused as such, he cannot be a prosecution witness. though an information is given by the accused himself to the police, he cannot be, considered as prosecution witness. And he rarely appears as defense witness also. So accused is left out. So evidentiary value of FIR is such that it corroborates as a circumstantial evidence to other the core evidences in the criminal cases. But that is about the evidentiary value of this FIR. Now, let us move to the next thing, that is information as to non-cognizable cases and investigation. Section 174. See, what happens here is no change is being made by the BNSS. Earlier section is kept as it is, only the section number is changed. As regards the information as to non-cognizable cases, section 174 is verbatim compared to the previous section regarding the non-cognizable offenses. But why I am telling it? It is because the Department of Police, that is Police Department in Karnataka, has issued SOP, new SOP, and also it has issued guidelines to the police to follow in respect of this information regarding non-cognizable cases. I'll come to that. What are those in this SOP? Information to SHO. So procedure, what exactly is the procedure? Let's try to understand that. When any information as to non-cognizable offense comes to the police, and here the police can receive it if it is within their jurisdiction. So again, here, jurisdiction is necessary. Then within the station limit, that is the wording that is being used. And once he receives the information, the police, they should refer the informant and the information to the concerned magistrate. And a daily diary, they have to mention in daily diary as to what all information they received about this non-cognizable offenses. And every fortnightly, they have to send the report to the magistrate, jurisdictional magistrate. And no investigation without the order of magistrate. Important thing in respect of non-cognizable offenses is they can resort to investigation only if there is an order of magistrate. In cognizable cases, there need not be any order of magistrate to commence with the investigation. And also there may not be any warrant to arrest the accused in respect of cognizable offenses. But here in both the cases, there is need for two separate orders. One order is for the commencement of investigation. The other one is the warrant to arrest the accused if necessary. Okay, this is another thing. When a case relates to both cognizable offenses and non-cognizable offenses, that is, when any accused is charged with sections, some sections are non-cognizable and some sections are cognizable. Under such circumstances, the entire case is deemed to be cognizable case. And accordingly, the procedure is followed here. 173 procedure is followed. Okay, having said about the cognizable offenses and non-cognizable offenses and the information therein, now let us come to the stages of investigation. Supreme Court in H.N. Rashid versus State of Delhi, it has laid down 5 stages. It has identified 5 stages of investigation under which we have to verify all these provisions. First stage is proceeding to the spot. Once the information is received, the police should proceed to the spot. Second, ascertainment of facts and arrest of the accused if necessary. So they should go to the spot because they are ascertaining the facts and they are arresting the accused if it is necessary. Then discovery and arrest of suspected offenders. That's okay. Third one, discovery and arrest of suspected offenders. Then discovery means, there may be mahachars and all. That term is being used. Collection of evidence. Then receiving statements from the public, accused, etc. That is also being done. Then formation of opinion. First to 4, that is investigation. 5th is filing of charge sheet, formation of opinion. So that is the stages of investigation. Then relationship between police and judiciary. This is supposed to be understood by the students and also the teachers of law. This is very delicate issue. What is to be understood here is a magistrate is kept in the picture at all stages of police investigation. It means Whenever the police are investigating, for every now and then, they need to approach the jurisdictional magistrate for various reasons. So everything is happening under the nose of a jurisdictional magistrate. But the magistrate cannot direct the police as to how the investigation is to be conducted. That is not his power. Police are free in that respect. So in that case, there are cases. Once the offense is disclosed, investigation must necessarily follow in the interest of justice, and the court will not normally interfere. So court should not interfere in the process of investigation. If the materials do not disclose the offense, the High Court can be approached under Article 226 of the Indian Constitution. And under 482 also there can be petitions before the High Court. So what does it mean? Whenever investigation is taken up by the police, anyway, if the general public have any grievances, the magistrates do not interfere in that. So it's quite probable that the public may file writ petitions under Article 226 before the High Court, or the petitions under 482 before the High Court. That is quite possible. So when such is the situation, that under the direction of the High Court, then there may be investigation in a particular line. And usually the High Court will also not consider these applications, stating that first you approach the jurisdictional magistrate. And jurisdictional magistrate will collect the information about the investigation that has happened so far. So that only amounts to check and balances on the powers of police. Then police officers' power to investigate cognizable offenses. This is important here. We have seen information in cognizable offenses. We have seen information in non-cognizable offenses. Now, what are the powers of police officer in respect of investigation of cognizable offenses? First of all, they don't need any court order, as I said. And this offense must have been committed within their limits or jurisdiction. Third thing, this investigation, if the case is very serious and grave, the superintendent of police may make or appoint a deputy superintendent of police to investigate instead of regular police. Then proceedings of the police not to be called in question before any court. Means proceedings of investigation cannot be challenged before any court. That is the protection given to the police to investigate. Magistrate, while taking cognizance, can direct investigations against a public servant. It means, whenever the magistrates are taking cognizance of any offense, there is some procedure. Only after that procedure, they may direct the police to take the cognizance of such offenses. The two conditions, whenever any complaint is filed against public servants before the courts will not take cognizance of such offense unless there are two materials or documents. Number one, report of the superior officer. So before taking cognizance of the offense against the public servant, because that offense is alleged to have been committed within the course of his duties as public officer, then his report of his superior officer has to be obtained, plus his version or his assertion should also be considered. Then only the court may direct the cognizance, or it may take into cognizance, it may direct the investigation of such offenses. Discretion is there with the police. So generally, what is the procedure for investigation now? That we'll try to see. Information goes to SHO or the station house officer. There is a reason to suspect that the cognizable offense has happened. Report forthwith to magistrate. So report will go to the magistrate. Then the police will go to the spot and there will be search and arrest if necessary. Search and arrest if necessary. Doesn't mean that in all the cases of cognizable offenses, arrest has to be made. Arrest is to be made only when it is necessary. When accused is not named in the information or FIR or the complaint, the station house officer may depute a subordinate officer to go and make the investigation. So if no ground to suspect, it means after verifying if there is no ground to suspect anyone when the person is not named, they may not proceed with investigation. In respect of sexual offenses, the investigation must be made by visiting the residence or place of choice of the concerned woman. Women police officer has to be, there while these statements are made, and it has to happen in the presence of a relative, and there has to be audio video recording of the statement by the woman who is the victim of sexual offense. Then fortnightly report by the police to the magistrate regarding this investigation. Then if the offense is punishable with 7 years or more punishment, it means if it is a heinous offense, now it is a duty upon the investigating officers to ensure that the forensic experts come to the scene of offense and they collect the DNA profiles. So DNA profiles and forensic, experts have to come to the place and they have to collect the DNA profiles to make the evidence scientific. This is mandatory now. So this is in respect of those offenses which are punishable with 7 years or more. IO has the duty to ensure that the forensic experts come to the scene of offense. But it can't happen immediately. So there has to be time limit for some time for the state government to ensure that sufficient forensic experts are available. So 5 years time period is given to the state to achieve this target. But now the state government is fast enough and it is recruiting lab technicians to this forensic department. Okay. Now after this, there are certain formal things like the submission and transmission of reports, and the report comes to the court. The much of the changes are not there in this. Now I'll come to few more important things. Examination of witnesses by police. It means earlier we had 3 sections, 160, 161 and 162. These were the 3 sections. Now we have these 179, 180 and 181. These sections are there. What is happening there is examination of person acquainted with facts. After the information has reached the police, when they are investigating, the police have to examine the person who is acquainted with the facts of that case. It may be the neighbor, or it may be the family members of the accused, it may be the family members of the victim. So they are supposed to investigate or examine these persons as witnesses. And such persons are bound to answer the questions of police unless the questions are incriminating. It means if they are involved, if they are incriminating themselves, then because that protection is again given under Article 20 to those people. So that is examination of them. Then the statements given by the persons to the police, they are reduced into writing. And even now, there may be audio, video recording of those statements. Means 161 and 162 statements. Now the new sections, 182, 182 are there. The statements of the people are now, or persons are now reduced into writing. Even audio, video recording is also being made. And in respect of sexual offenses, witness is to be examined by WPO, women police officer, or at least in the presence of women officer. That is mandatory now. And such statements are not to be signed by the person making it. Important thing, we have read it under 161, now also we are reading that any statement made to the police should not be signed. Police should not take the signature of the persons making the statements on them. It is to ensure that the people freely and voluntarily state before the police. If they are made to sign, they may deter to visit the police station next time at least. So there will be public deterrence in visiting the police stations. So the signature is not mandatory, or it should not be taken at all. And this statement made before the police during investigation, it should not be used for any purpose. It means it should not be used against that person for any purpose. But there are certain exceptions to this. One is when the prosecution witness deposes, and if he is deposing contradictory to what he stated before the police, the accused can use this statement before the police to contradict him in the cross-examination. This is one possibility. Another possibility is if the witness he has stated one thing before the police, if he is making improvement over that statement in the court, in the form of evidence as prosecution witness, the accuser may object to that. This is one thing. In other words, in some cases, if prosecution witnesses become hostile, then the public prosecutor may contradict them by way of using the statement made by that witness before the police. So these are the purposes for which this statement made before the police may be used. Otherwise, it is not an evidence against the maker, nor against this accused. There shall be no inducement, threat, or promise by the police while they are taking these statements from the people, including this accused person. But if the accused is voluntarily confessing, they can record it. What will happen to its evidentiary value, that we'll see later. But they can record that statement of the accuser also. Then recording of confessions. Earlier we had this section 164 as regarding these confessions being recorded. Now we have a new section. Section is same, almost same. Not much changes are made. But what this section says, let me see so that we can see as to what change has been made. Recording of confession or statement. So what 183 provides is, under that, either there is the recording of the statement of the accused, that is confession, or there may be the recording of statement by any witness. By whom? By any magistrate of the district. It means if it is in Tumkur district, if the FIR is lodged in Tumkur district, if the investigation is taking place within the Tumkur district in any police station, any magistrate in the entire Tumkur district may be approached for recording this confessionary statement or the statement of the witness under 183 now. Earlier, it was just a magistrate. And it was not stated whether within this district or outside the district. Now, the district parameter is being laid down. Then recording during investigation or before trial. So 164 statement should be obtained. If at all the police are arranging for that to be recorded before the magistrate, they should do it during the investigation only, not once the trial commences. So much before the trial, it should commence. Okay, that is the timing as to when it can be taken. Then audio video recording. If the statement before the magistrate under 183 is recorded, there may be, not mandatory, there may be recording of that through video. So recording is it is being permitted but not mandatory. Okay, audio video recording. When the audio video recording takes place, the advocate for accused has to be present. That is mandatory now. Steps to be followed. All these things we know under 164, that the magistrate should warn the accused that he need not confess. That if he confesses, it will be used against him. That it will say that he is punished. So all these warnings he has to give. That is because that is how Article 20 of the Constitution, right against self-incrimination, is being ensured and enforced here under the criminal procedure. So magistrate has to follow the procedure, and the procedure is same as compared to 164, now under 183. Statement has to be recorded. If it is a statement of the witness under 164, that is now under 183, not the confession. Statement has to be recorded as evidence in the court. It is recorded under oath, no? So the magistrate should also record this under a oath. And as the questions are asked in the court and the answers are elicited, now here also the magistrate should ask the questions to the witness and elicit the answers and record the same. That is being mentioned. In sexual offenses, the recording of the statement must happen as soon as the offense comes to the notice of the police. Delay should not be there. Woman officer or a male officer in the presence of a woman. So woman police officer has to be there. If she is not there, woman officer. If she is also not there, in exceptional circumstances, male police officer may also, but there has to be the presence of a woman. So this is the recording has to take place of the statement of the woman who is the victim of sexual offenses. Then magistrate shall record the offense punishable with more than 10 years. See, there is one provision now, newly inserted. That is, if the offense is punishable with more than 10 years punishment, and if the police have brought the witness to record their statements before the magistrate, the magistrates shall not refuse it. They shall record it. It is being made mandatory now. Earlier under section 164, the word used was magistrate may record. It means they could refuse the recording of statements of the witnesses under 164 for their discretion, for their own reasons. But now they don't have the option to refuse the recording of the statements of the witnesses now. But it is in respect of the offenses punishable with more than 10 years punishment in serious offenses. That is one change that is being brought about. Then if the maker of the statement is disabled, there has to be assistance of interpreter. Then the magistrate who records the statement under 183 has to forward it to the jurisdictional magistrate or the court, as the case may be. Okay. Now, medical examination of victim of rape, 184, section 184. This is a new change, or some changes are being brought here. What are those changes that we will try to see? Thing is, when any rape is being it comes into the knowledge through the information and all to the police, within 24 hours from the information, the police should see that the medical examination takes place before a government doctor. If it is not government doctor, any other doctor, but the consent of the woman has to be there. And what all is needed to be there in the medical report, what all the doctors have to state in the medical report. Now it is being specifically stated. The things to be stated in the medical report are name, address, age, materials collected for DNA, marks or injuries on the body of the woman, general health condition of the woman. All these things have to be mentioned in the medical examination. Doctors should also write their conclusions about their opinion and the reasons for that opinion. All important. Doctors have to mention whether it's consent of that woman is there for that medical examination or not. If the doctor writes that there is no consent of the woman for medical examination, woman consent should be treated medically. But that information given by the woman, which is in the form of report, cannot be used in evidence against the accused, because the woman consent has not given her consent for medical examination. It is her prerogative. This is the liberty of that woman. Then again, very important change that is being brought, namely, the doctor concerned, once a requisition is given to him to complete this medical examination, after that requisition, within 7 days, he has to submit the medical examination report to the IO. 7 days time limit is being specified. So delay is being avoided now. So that is the medical examination report. Now procedure, when investigation cannot be completed in 24 hours. This is another section which we should examine with some careful. Section 187. There is a lot of confusion about this. So let me make it clear. There are some confusions because I have read that there are certain confusions. Even in newspaper reports, it has appeared. Even there is a letter by Bar Council members also to the Home Ministry Secretariat, and newspaper reports are also bit erroneous. So let us know what the law is. Let us not bother much about the sections. Section 187, what it says in simple terms. Basically, once an information regarding a cognizable offense or any offense comes to the police, a cognizable offense, they should complete the investigation within 24 hours. That is the rule, cardinal rule, 24 hours. Usually that cannot happen, but 24 hours they have to finish the investigation. If they are not able to complete the investigation within 24 hours, how much time they have to complete the investigation? Until such time, the accuser might be kept in custody. What kind of custody? Either it is police custody or it is judicial custody. Okay. Now, time period. If the offense is punishable with certain punishments, for example, 7 years or more, less than 7 years, like that classification is made. Accordingly, we have one idea that in certain cases, charge sheet has to be filed within 60 days. In certain cases, charge sheet has to be filed within 90 days. So 60 days and 90 days case we have. Within that time, charge sheet has to be filed. Now, police custody. Until the investigation is complete, the accused can be kept in custody. What kind of custody? Either police custody or judicial custody. The law says you finish it off within 24 hours. If it is not possible, first 60 days, to carry out the investigation and to file charge sheet, 60 days time you have for the police. Within that 60 days time, during the first 40 days, 15 days police custody can be taken. Means police can take into custody the accused for a maximum term of 15 days. This 15 days may be taken at once or in a split up fashion. 2 days here, 3 days here, like that. But this period should not exceed 15 days. And this 15 days should be exhausted within the first 40 days of that 60 days entire. It means last 20 days, police custody cannot be taken. Okay. Coming to the 90 days cases, that is murder cases and all, in which the charge sheet should be filed within 90 days. Police custody can be obtained for a maximum period of 15 days, either at once or split up. Within the first 60 days, not in the last 30 days. Again, why this clause is being inserted? It is because 15 days police custody could be taken under the earlier CRPC first during the first 15 days. Accused used to abscond for around 15 days, then they used to appear after 15 days so that they won't go to the police custody. They will be into the judicial custody alone. So they were able to avoid police custody. To eliminate this mishap, the new code has come out with a provision under 187 wherein police custody can be taken for even during 40 or 60 days, up to 40 or 60 days case, as the case may be, as I stated so far. So this is 187. Now, important things that are brought as a matter of change now are non-investigation. If the police come to the conclusion that there is no need to take up investigation, then they should inform that same to the informant under 176 clause 2, where it appears to the police officer that there is no sufficient ground, etc. He shall inform it to the informant. He shall notify it to the informant. So here only informant is being mentioned. Even the victim should also have been informed in that. Time period laid down is 90 days. Okay. Then non-investigation. Whenever the police are not investigating into the matter, absence of materials and all, they have to mention it in the daily diary, and the same is to be submitted to the magistrates. That is non-investigation. Then information to victim bar informant. A new step has been introduced here. Under 193 clause 3, the informant or the victim must be informed about the progress of investigation to the informant within 90 days of the investigation. It means after the completion of investigation, the outcome of investigation, whether the charge sheet is filed or the investigation is given up, etc., the progress has to be informed by the police to the informant or the victim. This is a sound principle which is being adopted now under the new law. Now, speedy trial, expediting the trial process. In less serious cases, petty cases, summary trials are now made mandatory. Then in other cases, summary trial can take place wherever the punishment is up to 3 years only. So that the magistrate has the power now. Then report on completion of investigation. This is good. Once the investigation is over, now the police file charge sheet to the court or the magistrate. That is under section 193. They should not make unnecessary delay. And investigation in cases of special offenses and the POCSO, for example, they shall be completed within 2 months from the date of information. Again, there is now some sort of reconciliation between POCSO Act and the CRPC as regards the time period for investigation. Like that, there are certain rules for this report of completion of investigation. Now, let me come to this cognizance of offenses. I think I have another 3 minutes time. I'll take this 3 minutes time. I'll conclude that. Then, if there are questions, I can take up. Cognizance of offenses by magistrates. On receiving complaint, including complaints under the special laws, the police filed the report to the court. Okay. Then what happens there is, police may come to know about this offense through the other sources also. That is called as suo motu cognizance by the police. Then, whenever there is suo motu cognizance of the cases, at the option of the accused, such cases may be transferred to the other magistrates also, because there should not be bias. Then there is something called as making over of the cases to the competent magistrates. Then cognizance of offences by Sessions Court. There are certain offences under 213 which are specifically to be taken cognizance of by the Sessions Court only. There, the cases are committed to the Sessions Court. Then only one court is mentioned now, additional Sessions Judge. Now, 3 types of courts: JMFC, Judicial Magistrate First Class, CJM, Additional Session Judge, and the Session Judge. This is the structure of courts now. Some restrictions on taking cognizance. Here, one change has taken place. So I want to cover up that change so that can conclude this session, because I have got so many other things to say. But within this time, these are the important things which I wanted to bring it to your notice or the knowledge here. First of all, offences of contempt of lawful authority of public servants, public justice, or documents given in evidence. In respect of these, the cognizance of offense can be taken up only when the complaint is filed by that lawful authority. For example, if any offense takes place in a court or in a public office, unless that public officers file a complaint, magistrate cannot take cognizance of that offense. And next thing is, offenses against the state or criminal conspiracy, etc., there sanction of the government is necessary. Then prosecution of judges and public servants, there also sanction is necessary. So unless the sanction is there, they cannot proceed to take cognizance. Then offenses against marriage, section 200. So in respect of matrimonial offenses, unless there is a complaint by the specified persons, the magistrate cannot take cognizance. Then cruelty upon a woman, cognizance only on complaint. So whenever a cruelty is alleged against a woman, so unless there is a complaint by the woman or concerned affected persons like her relatives, there can't be cognizance. Then under section 221, sexual intercourse by husband upon wife during separation. If the wife and husband are staying separately, under separation, whether the separation is judicial or otherwise, that is not being stated now. So cognizance, if the husband is, the cognizance on complaint by the wife, if the husband has indulged in sexual intercourse with her, this is an offense now, and this cognizance can be taken up only when the wife complains, not otherwise. So this is another restriction placed on that cognizance. Section 322, prosecution for defamation, complaint by aggrieved person only. Then in case of public servants, the sessions courts can take cognizance only when there is report of the police officer and version of the concerned public servant. So bar of limitation as laid down under section 414. This another limitation on the cognizance is that when the offense is punishable with less than 3 years punishment, there is limitation period to take cognizance. But if the offense is punishable with 3 years or more punishment, there is no limitation period which is being applicable. This also should be viewed as a limitation. Then no period of limitation is applicable if the punishment is 3 years or more, as I said. That is the limitation on the cognizance. Now let me come to this last issue which I want to complete here. That is private complaint. Earlier there was section 200, now it is section 223. Under new section now, the law is, whenever a private complaint is filed before the court, there has to be the examination of complainant and witnesses in person by the court. Substance of the examination to be reduced into writing. So the court should reduce into writing the substance of the version given by them, and it should be signed by the complainant and the witnesses. But now, this was enough to take the cognizance earlier under section 200. Now under section 223, there is a proviso mandating opportunity of being heard to the accused. It means the magistrate should not proceed to take cognizance just because there is the written statement by this complainant and their examination before the court. They should also give notice to the accused, and they should give an opportunity of hearing to him. Then only there has to be cognizance. So this has created certain problems amongst the practitioners now. Their apprehension is that in case of check bounce cases, for example, I'm straight away moving to section 142 as an example here. In respect of check bounce cases, when the private complaint is filed before the court, there will be written complaint. There will be the witnesses. So depositions take place. Now the report is ready with the court. But the court cannot proceed to take cognizance because it has to give opportunity of hearing to the accused. But the accused absconds. In most of the cases in NI Act, check bounce cases, accused remains absconding. What to do under those circumstances? Cognizance can never be taken until the accused is heard. This is the practical difficulty as asked by some practitioners. But my answer for this in two ways. One way is, there are sufficient provisions under the new BNSS to treat such persons as absconding and to proceed against them as though they are present. That is in absentia trial. This is one suggestion. Another interpretational solution is that, we have a section. That is section 4 and 5 of the Bharatiya Nagarika Suraksha Sanhitha. Section 4, it specifically states that all offences under the BNS, that is under the new IPC, BNS, shall be investigated, inquired, tried, etc. under the BNSS, new CRPC. Okay, all offences under the BNS should be tried under BNSS. That is subsection 1. That is subsection 1. Subsection 2 of the same section, that is section 4, it states, subsection 2, it says, all offences under any other law shall be investigated, inquired into, tried, or otherwise dealt with according to the same provisions, but subject to the enactment for the time being in force, regulating the manner or place of investigating, inquiring into, etc. under such law. It means, if there is any investigation procedure or the trial procedure laid down under the special law, if there also you should follow the BNSS only. But if that special procedure is different, you should follow that special procedure. Now coming to the NI Act, Negotiable Instruments Act, there is under section 142, 143, etc. We have a special procedure wherein if a written complaint is there to the court shall take into cognizance such offences. So under such circumstances, the court can rely upon this section 4 and also section 5. Nothing contained in this Samhita shall be, in the absence of specific provision to the contrary, affect any special or local law for the time being in force. It means whatever procedures that are being laid down under POCSO, JJ Act, NDPS Act, or Negotiable Instruments Act are not to be affected by BNSS. That is how opportunity of hearing to be given to the accused need not be read into the check bounce cases. That is what my interpretation goes. We have to see in the course of time what may happen. So this is what I wanted to say, and I am now open for the questions. I'm stopping the sharing here. Yeah.
Thank you, sir, for an insightful session on the Bharatiya Nagarika Suraksha Sanhitha. Your expertise has greatly enhanced our understanding about the subject. With your permission, we will now proceed to address the questions and queries submitted by our participants in the chat box. To begin with, Srimati Kalpana ma'am says, "Good evening, sir. Thank you very much for clearly explaining the changes brought about by the new law. Sir, now that protection is given to witnesses, can we now expect witnesses not to turn hostile?" This is the question from Kalpana ma'am.
Okay. Right, madam. Witness protection. Witness protection. Now it is being thank you, madam, for the question. It is a timely question and it is also an appropriate question under the present circumstances. Yes, witness protection is the need of the hour. And hostility of the witnesses is also the problem. Now, why hostility is happening? When the witnesses are threatened, they are under the threat, they may become hostile. True. To that extent, that problem can be cured with the witness protection scheme. But under the Indian context, witnesses are becoming hostile not exactly because of the threats, but because of their own inherent problems. For example, societal reasons, family problems, or there are illegal agreements, compromises, etc. Money matters. Money enters into the compromises. Even in murder trials, what happens is people become hostile because of money, not because of the threat. So how to overcome these illicit, interceptions in the criminal trial? That's not exactly that's not only within the witness protection scheme. Witness protection scheme, I think partly it can solve the problem of hostility of witnesses. To solve the problem of hostility of witnesses, I think we need to overhaul the system of criminal prosecution, because this the police mechanism and the prosecution, they have to be reformed, and also there is need for what we call as the accountable public. So, and that is a very, very tough thing. So as I say, there is no direct correlation between witness protection and this hostility of the witnesses. That is not a solution in total terms.
Okay, sir. Thank you, sir. Next, Dr. Bhuvaneshwari S. Kolaki says, "Thank you for a wonderful session." She asks, "Sir, what is the evidentiary value of electronic evidence and forensic evidence?"
Okay. You are just slowly making me to, in fact, you have pushed me to the evidence. Okay. Evidentiary value. Now we have two types of evidence under the evidence side. That is documentary evidence and the oral evidence. Now your question pertains to the documentary evidence, and within that particularly the electronic and the evidence, the electronic and digital records. What is their evidentiary value? Yes, one thing is Section 2 now. It explicitly provides that the electronic documents are on equal footing with any other document, and total evidentiary value is not at all less in respect of the electronic documents. They are on par with any sort of document. That is the clear answer given. And coming to the question in another angle, namely, when you can consider them on par with full-fledged documents, that is when we prove them in accordance with the law laid down. Earlier, there were two sections under the Indian Evidence Act, Section 65A and 65B. Under Section 65B, there used to be the necessity for a certificate. When a matter is entering a device, computer device, if it is brought out in the form of output, to authenticate that this is from that device only, there was a necessity of any certificate from an expert, from that person who is holding that computer. Now, what has happened is the definition of primary evidence itself is enhanced, and that necessity of certificate, that circumstance is very less now. Only in respect of those computer devices which are kept in offices like the police stations on the courts, you need certificates. In other cases, you can, for example, I am now delivering a lecture and you are, having it in Zoom platform. Suppose it is live streamed in YouTube. Somebody records in some other device in the same way. That is also original now. No need to provide any certificate. He himself can produce it as original evidence now. That is a primary evidence. That is how now the ease is made, or it is very easy to produce electronic evidence now as evidence. It has got full-fledged evidentiary value.
Okay, sir. Thank you. Next, Jaykumar sir asks, "Sir, what are the important deletions in the Bharatiya Nagarika Suraksha Sanhitha 2023?
Yeah, deletions, as I said, certain names are, first of all, this India is deleted, Bharatiya has come. This Vakil, barrister are deleted, advocate has come. And certain terms are deleted. And, more than this, deletions are found, more in BNS than in BNSS. And other than this formal words, not much deletions are made in BNSS. Only these formal deletions are made.
Okay, thank you, sir. If there are any queries, participants can unmute your mic and ask.
Yes.
Okay, sir. Thank you, sir, for thoughtfully and thoroughly addressing each question, showcasing your deep knowledge and commitment to the field. As we conclude this session, I now invite Srimati Subhashini Dimpleby, Assistant Professor, to deliver the vote of thanks.
Before that vote of thanks is taken up, let me wholeheartedly thank the principal, Dr. Kempegoda sir, for involving me in this process of FDP. And also I am thankful to Madam you, because you are in touch with me since this FDP began.
Thank you, sir. My pleasure.
I'm thankful to you, Madam Bhuvaneshwari, and all
Thank
my
you,
colleagues
sir.
there in Vivekananda. I'm thankful to all of you for making me to involve in this meaningful, process. Thank you. Thank you very much.
We are
Could I
honored.
please
Thank
disturb
you.
you?
Thank you.
Could I please disturb? I wanted to ask you a question. I could not.
Please,
This is
please,
Sumitra
madam.
here.
Yeah,
Thank you
madam.
for the wonderful session. I don't have much knowledge about the criminal law, but when I was listening to, when you were telling us about the cognizance of the offense, you told me that when a husband and wife are separated, maybe by
Yes.
law or by factually, in case there is resumption of cohabitation, and if the wife complains, that can always be taken cognizance of. So, don't you think this provision is in contravention of the interest of the judiciary, wherein judiciary wants to protect the institution of marriage? Now, in this particular scenario, if the husband, the husband can always be apprehended that the resumption of cohabitation can always be used against him. So, because of which, don't you think the marriages will break?
Yeah.
Or it prevents him from coming back?
Yes, madam. As you,
I don't know if I am right. I need your clarification in this.
Yeah. Madam, I understood what you are telling. See,
Yes,
the
sir.
concern here is, when the husband and wife are under separation, whether it is
Okay.
under law or factually, they are under a separation for whatever reason. When they are under
Yes.
separation, if the husband indulges in forced sex with the wife, it is an offense. Okay. Against this, now the wife can complain. It can be taken cognizance of. Yes, it can be taken. Now the question is, when they are not yet totally separated, when the divorce has not been there, then when the husband is indulging in sexual intercourse with her, it is a sort of cohabitation. It is a sort of, some sort of, compromise between them. It may help in, sustaining that marriage. So instead of, considering it as a wrong, if it is considered as a wrong, the institution may vanish.
Yes,
That's the
that's the
concern. That is
question.
the apprehension. I do understand that. But now what has happened after the decriminalization of adultery is that,
Yes.
the individual rights are prominent than the institution of marriage. Especially after the decriminalization of adultery. Now we are, we have forgotten about the sanctity of the marriage now. The women rights, or not exactly women rights, individual rights. I'm wrong if I say that it is women rights. The individual rights are more prominent than this institution of marriage and the certain obligations under the marriage. So there is a fight between the obligations and the rights. The rights are winning over the obligations.
Yes, sir. Yes, sir. Thank
That's
you
what
very
I
much, sir.
think.
Yes, sir. Thank you.
Yes.
Thank you, sir, for addressing the query.
Yes.
May I now request Subhashini ma'am to propose the vote of thanks.
Good evening, everyone. It's my privilege to propose vote of thanks for today's faculty development program. I would like to express my heartfelt gratitude to our esteemed resource person, Dr. M.K. Matolli, Associate Professor, Department of Collegiate Education, Government Law College, Hode Narsipura. Thank you, sir, for sharing your knowledge and expertise with us today. The session was truly enlightening, sir. I would also like to express my gratitude to our management being the driving force behind this program. I mention my deep sense of gratitude Sri M.R. Lakshmi Manohar sir for his invaluable support and guidance. I would also like to thank our respected principal Kempe Gowda sir. Your leadership is a constant source of inspiration for all of us. I would also like to acknowledge our FDP coordinator Srimati Nirmala P. Hegde ma'am and our IQAC coordinator Dr. Bhuvaneshwari ma'am for their meticulous planning and execution. I also thank all the principals, participants of various law colleges for your active participation and contribution. Thank you one and all.
Thank you, Bhuvanesh. Thank you, Subhashini ma'am, for your heartfelt and gracious words. Before we wrap up, I kindly request all participants to fill up the feedback form, which has already been shared in the chat box, to help us to improve and enhance our future programs. We look forward to your participation for the next session, that is on Monday, 12th August, on the topic Bharatiya Saksha Adhiniyama 2023, with special reference to confession by Honorable Mr. Justice Panindra Upalokayukta, State of Karnataka, and former Judge, High Court of Karnataka. Thank you, sir. Thank you all once again for your participation, thoughtful questions, and enthusiasm, which have made today's session meaningful. Thank you, one and all. Thank you, sir. With your permission, can we end the session, sir?
Nirmala, may I end the session?
Yeah.